You've definitely heard about or even worked minimum wage at some point in your life. You know, it's that chapter in history class you forgot about, or that poster in the break room you never look at. It's just one of those things that have always been around. Or was it? Let's start on May 20th, 1907. The Secretary of Department of Commerce and Labor just signed off on the Census Bureau's latest report about an ever-growing demographic in America. The Census Bureau collects information from its citizens through its namesake, the census, which is a series of questions answered by every household every decade. These questions include things such as your name, occupation, race, sex, date of birth, and even your parents' place of birth. It then compiles this information into various reports about the country's people and economy. This specific report came in at a serendipitous time as Congress had just passed an act for a special investigation of the, quote, industrial, social, moral, educational, and physical condition, end quote, of this group. While not as comprehensive as Congress's request, the report is a good starting point for us. It was about the increasing number of working women, and it was called Statistics of Women at Work. The report gathered most of its information from the 12th census, which was done in 1900, and compared itself to earlier decades, the 1880 and 1890. Although there were undoubtedly working women before this time frame, women workers were just starting to be represented in the census beginning in 1870. The 12th census questionnaire considered workers as those who were in gainful occupations for, quote, every person 10 years of age and over occupied in gainful labor, end quote. This and other reports at the time make the distinction at 16 years and over for adults and 15 years and below for children. A gainfully employed person is admittedly a mouthful, so for brevity, let's refer to them as breadwinners, as they do in the census. Now, what does the Statistics of Women at Work report show? In 1880, about 16% of women were breadwinners, and in 1890, it went up to 18.9%. In 1900, it went up again to 20.6%, which was 4.8 of the 23.5 million women in America. In 1900, approximately 22.5 million of the 24.9 million men were breadwinners, about 90%. This 90% is consistent for the previous decades, with one just having a 0.1% change. So, why did women work in the first place? The report mentioned two major factors that decided whether a woman was working or not. The first being married. Marital status was grouped into four categories: single, married, divorced, and widowed. 57% of all women were married. However, married women made up only 16% of the women workforce. Most breadwinners actually came from single women, usually between the ages of 16 to 24, which was the age bracket before marriage was expected. Single women were about 31% of all women, but consisted of 65% of all women breadwinners. Widowed women were 11% of all women, and despite being less than a fifth of the number of married women, they were 17.7% of the women workforce. Finally, there is the smallest group, divorced women, being at 0.47% of all women, and they were 1.3% of the workforce. It may feel strange in our current times with dual incomes being the norm, but back then, jobs were seen as a temporary way for a single woman to support her family until she could get married. At that point, her husband's income would take care of the family's expenses, unless he was on the lower end of the pay scale and would need his wife and children to work as well. Divorced women tended to be older, often had children, and did not have a husband to work for the family, so many needed to fulfill the breadwinner role themselves. This is also true for widowed women, but to a lesser degree. Now, I don't want to imply that being married was a free meal ticket for women. It was pretty much their next job: housework and childcare. Actually, this was what most working women did as well. Domestic service as a profession would be the most common occupation for women, with 24% of all women workers in 1900. However, As time went on, all categories of women increased their participation rate. The other contributing factor was the opportunity to work, which was based on if you lived in a city or rural area. The census classified a city as a location with a population over 50,000 and rural areas as under 50,000. Although 50,000 seems a bit arbitrary, 76.9% of all rural people lived in areas with less than 2,500. If you were in the city, you were more likely to work. 28.3% of the 5.8 million women in the city worked, while 18% of the 17.6 million women in rural areas worked. The study noted that cities had a greater disparity in the wealthy and poor, but they offered a greater variety of jobs compared to rural areas which were primarily focused on agriculture and were a bit more level in wealth. The study did note that there were other reasons that women may wish to be employed, such as a desire for a career or interest in a field, but they were deemed an insignificant fraction, and the study leaned towards economic necessity and opportunity as driving forces. So, we know why women worked, but why were more women working? Why now? This took place at the end of the 19th century, the Second Industrial Revolution. It was a time of innovation when much of our modern day technology could be seen taking shape. We got our typewriters with our QWERT keyboard, combustion engines that enabled the first car and later the first flight by the Wright brothers, and even radio and transatlantic communication were just now possible. Everything was modernizing, and the factory setting was no exception. According to the summary of the report on the condition of women and child wage earners in the United States, which took place from 1907 to 1909, and was actually part of that special investigation I mentioned earlier, mechanization would make what used to be skilled labor that took years of experience, muscle, and dexterous hands into a simple task that could be learned in an afternoon to a new hire. A clear example of this was seen in the textile industry. Pre-industrial revolution, textiles were made individually at home with simple looms operated by hand. However, factories in the early 1890s used looms that were powered by water mills, fully automatic, refilling or stopping for repair if needed, and up to 8 looms could be monitored by a single weaver. Of course, this would be beaten in the 1900s by Northrop looms, which were much faster than the last iteration, since one person could monitor 16 even faster looms. As a result, textile jobs lost their demand, their wages would decrease, and the excess workers were fired since machines required less workers to create the same product. These workers would then move on to another factory until mechanization was adopted there as well, rinse and repeat until the entire area and eventually industry was fully modernized. Sometimes they would move on to a sister industry that still required skilled labor, like the women who moved from textile to sewing and clothes making, where they would then later experience the same cycle with the modern sewing machine, eventually having to settle as unskilled labor. In a broad sense, women would replace men in affected industries, since men would leave these lower paid jobs to continue working in industries where physical strength was still needed, such as metalwork, to keep higher wages to stay as the primary breadwinner of the family. While women could now meet that job's lower strength threshold and accept the lower pay, there are some instances like the boot industry where introducing machinery had an initial opposite effect by bringing more men into the job, since earlier machines still required physical strength for greater output, but as more and more refinement happened, women were able to rejoin. While some thought that machines would destroy society by erasing jobs, the unemployment problem would be largely fixed by new emerging industries. Overall, mechanization led to a general push of women into the manufacturing industry. On a more local level, women were often called in as strike breakers, typically people hired by an employer to work in the place of strikers to continue their business and to outlast the strikers. After the strike was over, employers would often keep these women in their workforce, since they were seen as more controllable than men. So, women were becoming a more accepted part of the workforce, but how much were they paid? For this, we can look at the 1905 Census of Manufactures, which was actually the first census of manufacturers taken separately from the decennial census, the one that I mentioned at the start. The Census Bureau sends a questionnaire to every establishment and business every 5 years to report the wages paid and average number of wage earners. Now, this would not count things that were not establishments or businesses like domestic service, such as servants, since they were not part of an official business, which was the largest occupation from the Statistics of Women at Work report. But I still think this is a good source of information for the wage distribution of women wage earners. As you can see in the chart, wage earners are put into two categories, men and women. Here's the wage distribution between men and women. The difference between men and women is quite drastic. 66% of men and 14.1% of women were earning $9 and above. So, why were women as a whole lower paid? On average, men were paid $11.16 and women were paid $6.17, which is almost half the pay. However, this is a pretty simplistic comparison. We should control for industry, since the median wages for each industry should be closer if everything else is equal. The report did this by grouping 333 different specific industries into 25 general ones. We still see the wages favor men across every industry, but we start to see some variance among them, with the lowest difference being woolen, worsted, and cotton goods at 30 to 45%, and the higher difference being about 100% in lumber, machinery, and iron, and glass being the outlier with having 178% difference. We can go even further by investigating the specific industries for an explanation by looking at the summaries report of Chapter 1 and 3. In Chapter 3, the glass industry, there was a clear delineation of workers based on sex. The furnace room was operated by men and boys who worked with hot metal and glass, which was mostly a physical task, something that was seen as unsuitable for women. Women, on the other hand, were stationed in the finishing and leer room, which was called by the report as, quote, not difficult or requiring much skill, thus being lower paid. For textile, in Chapter 1, weavers were the most skilled jobs, which majority of the women and a similar number of men worked in. In fact, cotton mill weavers had male and female rates at 17 cents versus 15.4 cents respectively, and spinners had male and female rates at 11.6 versus 12.6 cents per hour respectively. This was the average wage based on pieces made, not a set hourly wage. What we can take from this is that wage discrepancy comes from women performing most of the unskilled labor in society, so on average being lower paid. This report investigated the cigar industry and stated this could also be applied to other industries like cotton. Women were rarely paid less than their male counterparts for the exact same work, and could even have exceptions where women had the potential to out-earn men, like the spinners. Generally, occupations for skill, training, and responsibility were in the hands of men since they were assigned to more difficult tasks with higher expectations of work and without assistance. For example, gilding pottery was a simple task performed only by women, while filling in complex designs, a more difficult task, was done by men. In these type of jobs, men were actually displacing women. As mentioned before, women worked with the expectation that it would be temporary until they were married, so experienced women with long careers were very rare. Furthermore, a culture of, quote, low self-assertion, lack of experience in organization, end quote, to form and join unions was prevalent in women, which would lead them to miss wages that men would have secured. All of this would contribute to the wage average being different. On the upside, this culture was changing with each generation having higher and higher rates of joining and remaining longer in the workforce and trade unions. Now, just because they were low paid, it does not mean that they were poorly paid. What did these wages mean back then? Were they enough to live on? In Chapter 5 of the summary of the report on the condition of women and child wage earners in the United States, they investigated several thousand women across 7 cities: New York, Chicago, Philadelphia, St. Louis, Boston, Minneapolis, and St. Paul. It was about women working in department stores, other retail stores, and factories, since the issues of living were more apparent in low-wage positions, as opposed to office and professional women. The study splits women into two categories: adrift, which meant having their own home or in some sort of boarding house, and living at home, which meant living with relatives who could provide financial support. The study estimates about 65,000, approximately 16% of women working these jobs, were adrift in these 7 cities. The average weekly earning of these women was $6.67. However, experience is an important factor in pay. Women living at home with family had an average experience of 4.7 years, while adrift women had 6.7 years, which led to about $1.01 pay difference every week. A dramatic difference which lends to further context to the women-men pay difference just by career length. It is difficult to estimate the cost of living with family due to pooled resources and shared expenses. However, the study says most women living with their families gave all of their money and got a living condition based on what the family decided. 84.3% of women in New York and 78.7% in Chicago gave all of their pay, so it is safe to assume they were living on a tight budget. The average weekly cost for adrift women is a bit more concrete. Weekly costs for shelter, food, heat, light, and laundry were $3.80. Average weekly cost of clothing was $1.38. More flexible costs include car fares at 60 cents a week, and the contributions for relatives were 44 cents a week, leaving about 45 cents a week on average for leisure. 1,568 women answered these expense questions, and 62% of them said they had nothing to spend on themselves and used all earnings to meet weekly ends. 22.3% gave a specific answer, which averaged to 37 cents left over per week. The rest said they had leftover money but did not specify. For a quick reference, a used car in 1904 was $200 or more. An 1,100 square foot home was about $2,500. Oh, I know. The clothing cost seems a bit absurd. A fifth of your weekly wage invested into clothing? However, the living wage of women workers by Women's Educational and Industrial Union in Boston said that this was typical of women of every occupation, including the higher paying professional jobs. The general reason was that women had to appear presentable to clients and customers, so they spent money staying in fashion or redesigning their existing clothing. Poorer women had to spend time fixing clothing or replacing the ones that wore out while in the factory. They probably spent this time and money to fulfill some form of social need, which you don't get very much of when you're cramped in a sweatshop for 12 hours a day. For women earning below average, they usually cut their clothing or leisure spending for more necessary items. To summarize everything so far, women were entering the workforce at an increasing rate due to the opportunity through machinery and necessity to provide for themselves and their family. Mechanization and the overall culture surrounding working women drove most of them to the lower half of the pay scale. It should come to no one's surprise for what comes next. If you were already working for pennies, what would you do if you were told you would be making even less? Lawrence, Massachusetts, 1910. It is home to one of the most progressive movements for workers and the largest textile mills in the country. The conditions there were terrible and yet typical of its time. According to Bruce Watson's book, Bread and Roses, Mills, Migrants, and the Struggle for the American Dream, a third of Lawrence textile mill workers died within 10 years, usually from breathing in fibers in dank, humid rooms, then suffering from tuberculosis, pneumonia, or anthrax, also called wool sorter's disease. If you were not crushed or mangled by multiple daily occurrences of machinery injuries, you were expected to live to the ripe old age of 39. As a comparison, doctors and ministers were expected to live on average to 65. Thus, a push for shorter work weeks, for obvious reasons, was launched, and they were rather successful. In January 1910, the work week at Lawrence Textile Mills was reduced from 58 to 56 hours, and the wages were increased to keep the same level of total pay. However, on January 1st, 1912, when the working week was reduced again, this time from 56 to 54 hours for women and children, their hourly pay remained the same, thus lowering the total pay. This translated to a 32 cents loss for the $8.76 average pay, a meaningful difference to the already low-paid textile workers. The workers' response? A strike. Most strikers were women, and the goal of the strike were a 15% increase in wage for the 54-hour work week, double pay for overtime work, and no discrimination against workers for their strike activity. The Lawrence textile strike would become known as the Bread and Roses strike, where their rallying cry was, quote, "Hearts starve as well as bodies. Give us bread, but give us roses," end quote. At full capacity, the textile mills had 32,000 people working, and the strike had over 10,000 participating. After 2 long months, on March 14, 1912, the strike was successful and their demands were met. The strike must have quite an effect on the little states of Massachusetts, as perhaps coincidentally several months later, on June 4, 1912, Massachusetts passed the first minimum wage law in the United States, Chapter 706 of the Acts 1912. It established the minimum wage condition, which was made of 3 people appointed by the governor, quote, "one of whom may be a woman," end quote. Sounds a bit patronizing, but you have to remember the 19th Amendment granting women the right to vote would come in 1920, so having a woman in a governing seat was progressive for its time. The commission was to, quote, "inquire into the wages paid to female employees in any occupation in the Commonwealth, if the commission has reason to believe that the wages paid to a substantial number of such employees are inadequate to supply the necessary cost of living and to maintain the worker in health," end quote. If a worker was found in violation, they would take equal parts employers, employees, and some disinterested party to form a wage board to determine minimum wage by time, production item, or if they could have apprentice or child workers. At 2/3 agreement, a wage was decided and sent to the commission, which would approve or disapprove it. So there you have it. 1912 was the year minimum wage first started. Well, not exactly. The Massachusetts law took time to implement. It feels alien to even imagine, but there was a time when we didn't have smartphones, TVs, or any of the gadgets that we take for granted. Information gathering was slow, and the government commissions even slower. Enacting a law is signing it into existence, but coming into effect is when the changes truly take place. So, in November 1913, minimum wage law first went into effect in Oregon. Yes, Oregon, coming out of nowhere to steal the title of the first state of actually having a minimum wage in effect. Massachusetts law would later go into effect in August 1914, taking 2 years and 2 months to get there, making it 3rd place. Yes, Washington came in for the silver medal, making its own law go into effect in April 1914. Poor Massachusetts, the location of great progressive change, to have its thunder stolen at the finish. At least we can credit with setting up the framework and commission that the following states would base their own law on. According to the 1931 Handbook of Labor Statistics, Part 1, Bulletin of the United States Bureau of Labor Statistics, in 1912, Massachusetts was the only state to enact a minimum wage law. In the following year, 1913, 8 states followed: California, Colorado, Minnesota, Nebraska, Oregon, Washington, Wisconsin, and Utah. In 1915, Arkansas and Kansas followed. In 1917, Arizona. In 1918, D.C., in 1919, North Dakota, Texas, and the territory of Puerto Rico, and in 1923, South Dakota. Now, minimum wage was not universally handled in the same fashion. Some places such as Arizona, Puerto Rico, South Dakota, and Utah had specific rates in their law, while other states relied on a commission to determine it. For enforcement, 2 states, Massachusetts and Nebraska, relied on public opinion to push companies for higher wages. The rest had provisions in their laws to enforce the new wage rates. A similarity among the laws was that they focused on women and minors. No law was written involving men. Anyways, just look at that. 11 years, and you have 15 states, a territory, and even the country's capital. By 1920, 8.2 million women were working. That's 24% of all women. What could possibly stop the government? Oh, hey, look, it's the government. The wages I mentioned were purely at a state level. In America, there exists another level, the federal government. The federal government consists of three branches: the legislative, which is Congress, meaning the House of Representatives and Senate, who authorized the investigation I referenced before; the executive, the president and cabinet, who manage the government agencies such as the Department of Commerce and Labor, which oversees numerous sub-agencies like the Census Bureau, who wrote those reports; and finally, our next topic, the judicial branch, which is the Supreme Court and the federal court system. The federal court system consists of three levels: district courts, the first level; circuit courts, the next level, which can set legal precedent within their geographic boundaries; and finally, the Supreme Court, which interprets laws over the entire country. There are 94 district courts, 13 circuit courts, and 1 Supreme Court. Federal court and Supreme Court justices are appointed by the president and are lifelong positions. Cases typically do not go straight to the Supreme Court. They are appealed in the district court, sometimes even before a decision is made, then appealed again in the circuit court to finally reach the Supreme Court. It can also be appealed from the state court side when a case is appealed in a state's own Supreme Court. I know, it's a bit confusing. And finally, if the Supreme Court itself chooses to rule over it, which are cases between states, a state and the federal government, public officials, citizens of different states or another country, or just by saying that they will when it is evident that the case is a national issue. It is safe to say the Supreme Court presides over the more decisive and contested cases of the country. Minimum wage would be one of them. Let's take a look at what they're doing all this time. In the Allgaier v. Louisiana case of 1897, the Supreme Court unanimously ruled that the state of Louisiana violated E. Allgaier and Company's liberty by prohibiting work with an out-of-state insurance company. Liberty is specifically stated in both the 5th and 14th Amendment, which we respectively know as the amendment that protects us in court, hence the phrase plead the 5th, and the amendment which gave citizenship as well as equal rights to African Americans in the United States after the Civil War, including all future-born or naturalized people. This case would be the first time liberty was interpreted to include the liberty to contract. It was the ability between two consenting adults of full mental competence to negotiate obligations of both parties, usually involving some exchange of goods, service, or money. Associate Justice Rufus Peckham would write in the majority opinion, saying that the state could not inhibit a person's liberty to, quote, enter into all contracts which may be proper, necessary, and essential, end quote, to make a lawful living. So, how does this relate to us? If you ever worked a job before, you most likely signed a contract, which determined many things such as the responsibilities, the hours, the location, and definitely the wage. Therefore, if you had two adults who agree to a contract, everything should be fine, right? I could then theoretically contract someone to punch a brick wall for hours for a penny an hour, since they just need to know the terms and that they have to agree. Well, not exactly. The vague definition of the liberty to contract is counterbalanced by the equally vague definition of police power, which is the government's ability to enact and enforce laws to uphold, quote, the health, safety, morals, and general welfare of the public, end quote. The following court cases will show which aspects of the liberty to contract the Supreme Court feels the state can step in. In the Holden v. Hardy case of 1898, Albert Holden contracted several of his workers to work in a mine longer than 8 hours, which a Utah law at the time prohibited. He was arrested, and he argued that the law was unconstitutional since it prevented certain contracts. Holden claimed that if a miner wanted to work extra hours for more money, he should be able to. Associate Justice Brown would go on to write the opinion of the court, which recognized that the state had the power to grant additional protection to people in particularly dangerous or unhealthy situations. The Supreme Court ruled against Holden, saying that the Utah law was a valid use of police power, since the cap on hours so as to limit the workers' exposure to the dangerous mining environment, which would fall under the health and safety of police power. Brown would go on to say that the state could intervene even against the employee's own self-interest due to the power imbalance between workers and employers. Quote, "The legislature has recognized the fact, which the experience of legislature in many states has corroborated, that the proprietors of these establishments and their operatives do not stand upon an equality, and that their interests are to a certain extent conflicting. The former naturally desire to obtain as much labor as possible from their employees, while the latter are often induced by the fear of discharge to conform to regulations which their judgment, fairly exercised, would pronounce to be detrimental to their health or strength. In other words, the proprietors lay down the rules, and the laborers are practically constrained to obey them. In such cases, self-interest is often an unsafe guide, and the legislature may properly interpose its authority." End quote. The court would rule 8-1 against Holden. So the state has the ability to regulate how long you work, but can it regulate how you get paid? In 1901 Tennessee, the Knoxville Iron Company v. Harbison case had the method of compensation under scrutiny, after a securities dealer named Samuel Harbison purchased coal credits at a discount of 85 cents per dollar and was not allowed to redeem them. This was against an anti-scrip law in Tennessee, so he sued and won in the state court. Scrip, by the way, is usually some form of credit or alternative currency with the company, which was how this particular company paid out 75% of the employees' wages, since they could pay out scrip earlier than actual cash. Knoxville Iron Company appealed to the Tennessee Supreme Court, lost, and appealed to the actual Supreme Court. The company's attorney was named Edward Sanford, who had argued that the law was abridging the liberty to contract, since it would force certain obligations, making scrip redeemable at face value within 30 days of issuance by the employee or a bona fide holder, which is someone who obtained it in good faith, like Samuel Harbison, or the employee may demand payment in cash instead. Associate Justice Shiras would go on to say in the court's opinion that he recognized this anti-scrip law was to level the playing field between employees and employers, since it would allow workers to purchase more coal at a better price elsewhere, and that it was enforceable and entitled to full recognition as, quote, law of the land, end quote, since it did not impeach the Constitution. He commended the act for promoting equality between employees and employers, as well as general peace and good order. Shiras would cite 3 other court cases, including Holden v. Hardy, in which the liberty to contract was legitimately limited by the government. The court would rule 7-2. Let's take a look at another case. During this time period, bakeries operated in tenement house cellars because of their low rent. That's about it. There weren't really any regulations to be a bakery, so any building, as long as they supported the oven's weight, could be a bakery. House cellars are obviously famous for their cleanliness, as wastewater from sinks, baths, and toilets would go down the drain and through the cellar to the sewer lines, a smell that did not get better with the warm summer air or heat from the ovens. These cellars had poor ventilation for the flour and dust, no insulation from the heat and cold, not to mention they were 5.5 feet tall, thus making many people slouch to fit in during their 74-hour work week. Truly a lovely workplace. This would come to change under the New York's Bake Shop Act of 1895. It limited hours to 10 hours a day, 60 hours per week, as well as setting truly revolutionary sanitation laws such as having no toilets within the bakeroom. In 1901, a baker named John Lochner was found in violation of the Bake Shop Act for making bakers work longer than allowed. And this case would be called Lochner v. New York. Lochner refused to plead and was found guilty. He appealed to the Appellate Division, lost 3-2, and appealed to the Court of Appeals, New York's highest court, and lost 4-3. He then appealed to the Supreme Court, which heard arguments on February 23, 1905. Lochner's lawyer, Henry Weissman, was actually a former lobbyist for the Journeyman Bakers Union and originally supported the Bake Shop Act. He changed his opinion on the act after he opened a bakery of his own. His argument was that the Bake Shop Act was an hours restriction with the appearance of a health regulation, and that experts at the time were fighting for better working conditions, not duration. Thus, limiting hours was not considered reasonable in aiding the workers' health. You have the usual 14th Amendment argument of restricting certain contracts as well. On the other hand, the New York Attorney General argued that the burden of proving a law unconstitutional fell to Lochner instead of the state having to prove its validity, and that the law was a health measure, so it was within the state's police power. Associate Justice Peckham would go on to state in the court opinion that contracts were not absolute. You could not contract to violate a statute, or to use one's property for immoral purposes, or to do any other unlawful act, and that police power is legitimate and should be used appropriately. He cites Holden v. Hardy as an example of valid police power in work hours, with the distinction of mining being a particularly dangerous occupation and the law being for a miner's safety. He also cites the 1901 Knoxville Iron Company v. Harbison case as a valid police power to equalize the worker and employer in wage matters. But he said this was all irrelevant to the Lochner case and could not be used to guide it. He found the Bake Shop Act wording inappropriate since it did not include a clause for emergent scenarios like the law from Holden v. Hardy did, thus setting a cap on a legal day's workload. He then says the Bake Shop Act was merely a labor law limiting hours and had no reference to health, safety, morals, or the welfare of the public. It only affects bakers, and that quality bread depends on the baker's work, not his hours. So this law only affected the bakers and not the public. And so, this limitation of hours was not within police power. While Peckham stated that this occupation was undoubtedly unhealthy, he said that the lower court's divided opinion meant that there was not enough evidence to conclusively say a baker's job met the level of unhealthiness that would require the state to step in, like for miners. Funnily, just like the lower court's rulings, the case would remain hotly divided at 5-4, except in this time in favor of Lochner. As a side note, the two cases Peckham cites, Holden v. Hardy and Knoxville Iron Company, had strong margins, and both had Peckham as a dissenter. Some of the other justices had some choice words for the majority in their dissenting opinion. Justice John Harlan would say that the courts should have no business in striking down a law based on efficacy, and should base it on the relation, or lack of relation, to things it is supposed to protect under police power. He would emphasize that the burden of proof falls upon the accuser, not the state, to demonstrate how it interacts with the 14th Amendment. He would also go on to cite several studies that the working condition of bakers were in fact harmful, such as work hours at night preventing proper rest, inhalation of flour, and long hours leading to cramps and swollen wounds. As a craft, bakers had an average lifespan between 40 to 50 years old, below that of other workmen, and that they were often the first to die in epidemics due to their weakened immune system. Reading these cases is a bit long and tedious, so I'd like to thank the next Associate Justice Holmes for only having 3 paragraphs for me to read, but they are cutting. He called out the majority as following some form of economic laissez-faire theory, a lack of government intervention in economics, something he believed the court should have no influence on their decision as their duty is to interpret law. He stressed that the government has intervened in people's lives before with Sunday and usury laws, and more modern examples like Holden v. Hardy, and that this case should be no different. Quite the step back, since this was the first case holding this kind of statute unconstitutional. Where do we go from here? Well, we have yet another maximum hours law, this time from the state of Oregon. In Oregon law, Sessions Law of 1903, stated that, quote, no female shall be employed in any mechanical establishment or factory or laundry in the state more than 10 hours during any one day, end quote. Fun fact, this time Massachusetts was quicker on the draw and had enacted this version of the law in 1874. Back in Oregon, 1905, Kurt Muller, a laundry owner, was convicted of making female employees work more than 10 hours a day, and so this was called Muller v. Oregon and would reach the Supreme Court in 1908. What was special about this case came from how the state's attorney, Louis Brandeis, would make the first legal brief of its kind, blending social studies and legal arguments. Now, credit where credit is due, all of the brief's information was compiled by his sister-in-law, Josephine Clark Goldmark, a legal reformer in the National Consumers League, and her sister, Pauline Goldmark. Their brief was 113 pages long, with only 2 of the first pages consisting of legal arguments, and the rest would talk about foreign and domestic law, outlining maximum hours, the difference between men and women, such as, quote, 113 pages long, with only 2. His brief was 113 pages long, with only 2 of the page. His brief was 113 pages long, with only the first 2 pages consisting of legal arguments, and the rest would talk about foreign and domestic law, outlining maximum work hours, and the difference between men and women, such as, quote, the anatomical and physiological differences, muscular strength, nervous energy, persistent attention, and application, which would lead to dangers specifically to women, such as the, quote, anatomical and physiological differences, muscle strength, nervous energy, persistent attention, and application, end quote, which would lead to dangers specifically to women. The brief would take passages from reports to further prove the complicated math of long, hard work taking a toll on the body on a daily and long-term scale. The defendant claimed that this Oregon law was abridging the liberty to contract, that it was class legislation since it did not apply to all persons equally, and that it was not a valid use of police power since the work was not unlawful, immoral, or dangerous to the public health. In Justice David Brewer's majority opinion, Lochner v. New York was mentioned as a precedent for not infringing the liberty to contract. However, this time it was between men and women. He mentions the Brandeis brief as providing evidence to the widespread belief of women's physical structure and functions. Constitutional questions are not determined by what is public opinion. However, when that very opinion is under contention and the driving force of the law, they would need to be taken into account. The court said that a woman's physical structure and maternal functions put her at an obvious disadvantage, and being a mother only compounds the difficulty. Even when not pregnant, long periods of work harms the mother, and a healthy mother is essential to raising children who are the future generation. If they are not taken care of now, the state will have to support them later. Therefore, a woman's well-being is a matter of public concern. The court also acknowledged the historical power difference between men and women by physical strength. The gap in education was only recently starting to be closed, and although women do have some advantages in life, when it comes to independent living, women certainly do not have the same level as men. The physical difference, such as strength, capacity for long labor, especially done when standing, self-reliance to exert rights and struggle for subsistence, and childbearing capabilities lead to both her and the future of society in the interest of the state. Therefore, special advantages will need to be afforded to women. Ultimately, this case would not overrule Lochner v. New York due to the distinction of differences based on sex. While some of the expert opinions of the Brandeis brief were later contested by future research, it was ultimately successful in court by the resounding success of the 9-0 verdict in upholding the Oregon law. The Supreme Court had been careful in allowing police power to intervene, often choosing it to balance for dangerous occupations or particularly exploitative business practices, or to support the future of society. Maximum hours was the first stepping stone in the workplace, probably due to how easy it was to see how harmful the effects of long hours were, with the distinction for women. With all of this in place, what would the Supreme Court say about low wages? Or at least for women? How long could it stay silent on a countrywide issue? Finally, we now come to the first time minimum wage was brought up to the Supreme Court, coming from Oregon yet again. If you recall, Oregon's minimum wage was set back in 1913. It followed the framework of the Massachusetts law, setting up a commission of 3 parties to determine minimum wages that could supply the cost of living and health and establishing maximum hours. The judge of the Oregon Supreme Court, Judge Robert Eakin, wrote the opinion citing Lochner v. New York as a case of maximum hours still being in contention due to the thin margin in the appeals and the Supreme Court. He cites the last case, Mueller v. Oregon, mentioning that women entering men's place is rather new, and that their physical structure lead them to needing special protections like maximum hours. Since this law was setting minimum wage for women, the Oregon Supreme Court would rule this law constitutional. This would then get appealed to the Supreme Court. The Supreme Court would end in a tie vote of 4-4 with 1 abstaining. So this meant it deferred to the Oregon Supreme Court's decision and did not strike it down for minimum wage law. However, this decision was not a majority and cannot be used as precedent for the whole country. Certainly a missed opportunity. But how could a tie vote happen? Remember our good friend, Lawyer Brandeis? He was here now as a Supreme Court justice after a delayed and rocky appointment from the Senate, and he recused himself due to a conflict of interest. Funnily enough, he had worked on this exact case's brief with Josephine Goldmark back in 1913 when the case was first brought up before the Oregon Supreme Court. Brandeis was appointed in 1916, so when the case followed him to the Supreme Court, he could not vote on it. Felix Frankfurter would represent this case in place of Justice Brandeis. Who knows what would have happened if another justice was appointed instead? It takes place in Oregon again. Wow. For a state with 1/6 of the population of Massachusetts, it was pretty loud. The 1913 Oregon law set maximum working hours to be 10 hours for both men and women in mills, factories, and manufacturing establishments, except in cases of emergencies, which required a 1.5 times pay for overtime. Overtime also had a maximum of 3 hours. Looks like someone was listening to Justice Peckham about those emergency clauses. Franklin Bunting worked his employees at a flour mill for 13 hours without overtime pay. He said that this law was made with the design of making the employer pay more than the actual market value of labor, being 14.5 hours of pay for 13 hours of work, and that this violated the 14th Amendment by overextending its police power. His argument was basically 2 points. Number 1, this law was not about hours of service, but really a wage law. And number 2, if so, it was unequal in its application as class legislation. The first section of this law states that its goal is to, quote, fix the maximum hours of service in certain industries. The Act makes no attempt to fix the standard of wages. No maximum or minimum wage is named. That is left wholly to the contracting parties. Not a good start for Bunting, but Associate Justice Joseph McKenna was even-handed, saying in the court opinion that the mere declaration of law does not make it right, nor does it make illegal to legal. McKenna wrote that this law was made to be a penalty, not permission. Penalty for a law is meant to be deterrent, and if the penalty was not sufficient to stop this behavior, it does not change the character of the law. Furthermore, laws are made to be flexible with the emergency clause and to prevent abuse by requiring higher wages. He goes on to say laws like this are a bit tentative in the beginning and get a bit more firm as time goes on as it becomes more commonplace. Again, the lack of perfection does not mean a lack of constitutional legitimacy. McKenna dismissed the contention of a wage law since employees were still able to negotiate the same rate. Bunting said that even if this law was in hours of service, that hours of service is not necessary or useful for employee health in these establishments. which is something he did not provide facts for. Both the Supreme and lower courts believed otherwise, since other industrialized countries had similar average working hours. Quote, Australia 8 hours, in Britain 9, in the United States 9 3/4, in Denmark 9 3/4, in Norway 10, Sweden, France, Switzerland 10.5, Germany 10.25, Belgium, Italy, and Austria 11, and in Russia 12 hours. The second point was that this law was unfair to employers of a specified industry since other industries were not subject to the same law. But the court did not bother since they moved with the ruling that this was an hours of service, not wage law, since wage negotiation was still available. If you notice the score 5-3, Brandeis recused himself again in this court since he had agreed to represent this case before he was appointed as a Supreme Court justice. Just another fun fact, Felix Frankfurter from the last case would represent this one as well in place of Brandeis. This really just feels like everything's repeating itself. It seemed like the court was getting more progressive with ruling maximum hours for both men and women to be constitutional. What happens when minimum wage comes around again? They had tied the previous time. The next case was brought forward by Willie Lyons and the Children's Hospital in opposition to the DC Minimum Wage Board. The interesting part was the parties involved. The women of the Children's Hospital were employees, and they were against Jesse Atkins and 2 other members of the Minimum Wage Board of the District of Columbia who were trying to enforce this law. Quite the plot twist. It's not the usual employer and employee conflict. The DC Children's Hospital employed a large number of women, and when the new minimum wage law came into effect, many of these women said they were happy with their current rates and did not wish for the raise. Since the hospital would cut jobs to compensate or even hire men to replace them, since minimum wage did not exist for men. The other player in this case is Wiley Lyons, an elevator operator for Congress Hall Hotel Company, who was paid $35 a month and 2 meals a day. She was satisfied with the work hours and wanted her current arrangement instead of the new wage, $71.50, set by the law. Her employer said that the wage board and the penalties for not following the new law were the reasons she was let go. Since men were not protected under the minimum wage law, a man was hired in her place. A strange turn of events, really. Mechanization would lead to women entering traditionally men's work, and now minimum wage was leading to the reverse. Associate Justice George Sutherland said in the majority opinion that the liberty to contract shall not be infringed except in exceptional circumstances. Negotiating had already been limited by maximum hours, but the exact wage was still negotiable. So in the court's opinion, adding minimum wage implied maximum wage and would be too constraining. Justice Sutherland said that with the 19th Amendment, women's right to vote, which was gained in 1920, and the increasing rate of women entering the educational realm, the non-physical difference between men and women was closing quickly. Therefore, women were on equal grounds to contract without special protections. Wow. Apparently, Justice Sutherland thought that gender equality would be achieved in about a decade after Mueller v. Oregon. Why don't we have that kind of speed anymore? Another problem that the court had with the DC law was that they felt it was too vague to enforce. The court said that the necessary cost of living, quote, is obviously not a precise or unvarying sum, not even approximately so, end quote. The costs could vary between person to person based on spending habits and living conditions, and it would be unfair to have different minimum wages for different occupations, since a woman's cost of living does not change if she changes jobs. Family and dependents further complicate this, so any set amount would be enough for some while inadequate for others. Quote, these orders fix the sum to be paid to a woman employed in a place where food is served or in a mercantile establishment at $16.50 per week, in a printing establishment at $15.50 per week, and in a laundry at $15 per week, with a provision reducing this to $9 in the case of a beginner. If a woman employed to serve food requires a minimum of $16.50 per week, it is hard to understand how the same woman working in a printing establishment or in a laundry is to get on with an income lessened by from $1 to $7.50 per week. End quote. Additionally, the law had the goal of also, quote, preserving their morals, end quote. Justice Sutherland said that morals do not increase with wage, so paying women more than their old wage through a minimum wage does not relate to preserving morals. Finally, the last problem is that the minimum wage only serves the employee by setting a minimum level of pay, sometimes at the employer's loss, regardless of their ability to pay. The court ruled 5-3. Interestingly, Sutherland was a former senator who opposed Brandeis's nomination to the Supreme Court. Must have been some awkward moments in there. William Howard Taft, former U.S. president, said in his dissenting opinion that employees taking the minimum are already prone to being exploited since they were in poor conditions and would accept anything at that point, thus being vulnerable to the greedy employers and their sweatshops. He thought minimum wage and maximum hours were the same in that there were restrictions on the liberty to contract to preserve worker health, upheld through Muller v. Oregon and Bunting v. Oregon. He disagreed with the implication of a maximum wage law through the minimum wage. While he was unsure about the efficacy of minimum wage in combating sweatshops and exploitation, he was adamant in the court's role to not rule based on the soundness of economy. The implication of maximum hours and minimum wage is that if they did not exist, then employers would have set lower wages and longer hours. Another fun fact is that he is the reason that the Department of Commerce and Labor are now two separate entities, something he did on his last day of presidency in March 4th, 1913. His opinion was concurred by Edward Sanford, who you may remember from the Knoxville Iron Company v. Harbison case as the company's attorney, now Supreme Court Justice. Justice Holmes wrote in his dissenting opinion that there were restrictions already to the liberty of contract, which were not special to other rights. Usury laws limited rates of interest, blue laws prevented the sale of alcohol, sometimes groceries, office supplies, and houseware on Sunday or religious holidays. Fraud restricts contracts to certain forms by prohibiting deception. He said that minimum wage law does not compel people to pay, only that it forbids payment below a minimum. Our absent judge, again, is Justice Brandeis, who did not participate in this case because of his daughter, Elizabeth Brandeis Rauschenbusch, who worked at the D.C. Minimum Wage Board from 1918 to 1923 as a secretary to the board. Wow, Brandeis couldn't touch many cases because of his past work and family. Must have felt really frustrating to have to recuse yourself over and over from things you worked so hard for. But it would have done nothing already to the 5-3 vote. I guess that was it. Federal minimum wage was ruled unconstitutional, so DC did not have a minimum wage anymore. But what about state minimum wage? Unfortunately, it was already falling apart even before Atkins. Let's take a look back. Nebraska and Colorado never entered a wage decree, so they never went into effect. Furthermore, Nebraska would be repealed in 1919. Texas would suspend theirs and later repeal it in 1921. Once Atkins was decided, it would be used as precedent for many cases to come. The state Supreme Courts of Puerto Rico and Kansas would follow this ruling in 1924 and 1925. The Minnesota Supreme Court ruled the law unconstitutional in Stevenson v. Sinclair in 1925, except for girls under 18 years old. A Wisconsin District Court would do the same in 1924, but it would revise its law in 1925 to go from enforcing a living wage to preventing a, quote, oppressive wage, end quote, meaning adults cannot be paid less than a minor. The Supreme Court itself would use the Atkins precedent in 1925 and 1927 for Murphy v. Sardell in Arizona and Donham v. West Nelson Manufacturing Company in Arkansas. North Dakota had to prove appropriations every 2 years starting in 1927, and Utah would lastly repeal its law in 1929. Of the remaining states, Massachusetts' law was allowed to exist since it was a recommendation on wage and relied on public support and shaming rather than a mandatory condition. Oregon, South Dakota, North Dakota, and California used both legislation and public opinion to enforce their minimum wage laws. However, the only state that was still handing out fines and legally enforcing its law by 1931 was Washington. It upheld its law in state courts by Larson v. Rice in 1918 and Spokane Hotel Company v. Younger in 1920. With the ultimate arbiter of law in the United States calling minimum wage unconstitutional, and all but one state having no legal enforcement, it seemed like the minimum wage law movement was stuck in its tracks. There's nothing that could possibly change the government's mind. Oh hey, it's the government. With minimum wage being ruled unconstitutional, it would take a huge shift in the economic and political landscape to even propose minimum wage again. The 1920s were a time of economic prosperity for a variety of reasons. The country was recovering from a wartime economy from World War I. The return of the soldiers into the workforce undoubtedly boosted the workforce, and people were moving from rural areas to cities for more opportunities. Goods like cars and radios were no longer luxury items and became widely adopted. Everything was looking good. The stock market was doing great. Almost too great. At the start of the decade, 1920, the yearly average of the Dow Jones Index, a collection of 20 companies that were meant to represent the American economy, was 90.01, and it peaked in 1929 at 380.33, with now 30 companies. Purchasing of investments for short-term gain was still rampant. It would continue to be a successful tactic as long as the markets kept going up. It seemed like it could only go up until everything popped on Black Thursday, October 24th, 1929. Black Thursday was when the market fell 11% of its value at the opening. However, the Dow Jones only fell 6 points after banks and investment companies bought up the stock to stop the crash, setting a record of 12 million shares being traded in a day. Unfortunately, Black Monday would follow on October 28th, leaving the market 12.8% down. Black Tuesday would follow up with a new record of 16 million shares traded and an 11.7% drop. Confidence in the market fell and would reach a yearly average of 64.53 in 1932. Not good. In a response to an agricultural issue earlier in the decade, these two fine gentlemen, Senator Reed Smoot and House Representative Willis C. Hawley, would propose a tariff. Tariffs are taxes imposed by a country on another country's exports for a variety of reasons, usually to generate revenue for the country or to protect domestic producers from foreign competition. This can cause countries to export less on those goods and those purchased tariff goods to experience higher prices. The Tariff Act of 1930, which was nicknamed Hawley-Smoot Tariff, would raise tariffs by an average of 6% on U.S. dutiable imports. There was just one teeny tiny detail that these men forgot. Every other country could do the same. Despite farmers, newspapers, foreign governments, and over 1,000 economists protesting this tariff, it was signed by President Herbert Hoover on June 17, 1930. According to Chris Michener's The Smoot-Hawley Trade War, countries that responded with retaliatory tariffs reduced their imports from the United States by about 28 to 33%, while countries that protested the tariffs reduced their imports by 15 to 22%. To clarify, protesting meant that they raised the tariffs, but not particularly towards the United States. Retaliating countries were smart to not appear obvious by directly targeting the United States, but instead focused on U.S.-focused goods. They went after automobile, movies, and other U.S. growing industry targets rather than a general tariff on all imports. A series of banking panics would not help the situation. A banking panic is when customers lose confidence in their bank and pull out cash from their accounts. A bank does not have to have all of its money in its cash, so it will have to then liquidate loans to meet customer demands. So when a banking panic occurs, a bank may then fail due to sudden withdrawals. 4 banking panics would occur over the course of several years, that being in fall of 1930, spring of 1931, fall of 1931, and fall of 1932, causing a fifth of banks from 1930 to fail. With the country falling apart, it would need someone drastic to take drastic measures. That man would be Franklin Delano Roosevelt, the 32nd president. President Roosevelt was inaugurated on March 4th, 1933, which unfortunately for him was a month after the latest banking panic. At this point, 25% of the workforce was unemployed. Immediately, Roosevelt would get to work, declaring a national bank holiday on March 6th, just 2 days after taking office. Banks were closed, meaning no money in or out, until a government inspector deemed the bank solvent. With some confidence restored, the American people returned $1 billion by April. Roosevelt also signed the RTAA, which is the Reciprocal Trade Agreement Act, on June 12, 1934, which gave him the ability to negotiate lower tariff agreements between the United States and foreign countries, as long as the other country lowered their tariffs as well. All of the negotiating could be done without Congress's approval and was basically a faster way to resolve this. However, critics would say that this agreement was Congress surrendering part of its power and responsibilities under the Constitution, Article 1, Section 8, to the President. To balance the President's power, tariffs had to be approved by Congress in a simple majority, and the RTAA would need Congress approval for extensions. These events kind of highlight what kind of president Roosevelt was and how he acted. You can see this also in minimum wage. When Roosevelt appointed France Perkins to be Secretary of Labor, which she remains the longest-serving Secretary of Labor, she said she would accept if she could advocate for a minimum wage and maximum hour law. Roosevelt said yes. She then pressed him further, quote, "Have you considered that to launch such a program might be considered unconstitutional?" End quote. Roosevelt responded, quote, "Well, we can work out something when the time comes." End quote. I think that kind of summarizes the President Roosevelt was. President Roosevelt then signed the National Industrial Recovery Act on June 16, 1933. The purpose of this act was to, quote, "encourage national industrial recovery, to foster fair competition, and to provide for the construction of certain useful public works." End quote. The Great Depression was a problem too big for a single man to tackle, even the president. So the act allowed the president to create agencies to do so. Section 2 allowed for the president to, quote, "create agencies that can enact his powers, and that the agencies which would dissolve after 2 years or earlier by Congress and the president, if the emergency for this act has been resolved." End quote. 2 years seems a bit short to resolve the worst economic crisis in American history, but Roosevelt was also a pretty unconventional president. The National Industrial Recovery Act created 2 organizations. One was called the Public Works Administration, the PWA, which oversaw large-scale public works projects, one of which is the San Francisco Golden Gate Bridge, which was completed ahead of time and under budget, which is rather a pretty rare thing in government projects. However, we care more about the other agency, a rather controversial one called the NRA, which stands for the National Recovery Administration. How exactly did the NRA try to resolve the economic crisis? This would come from Section 3 of the NIRA, Codes of Fair Competition. The president's grand plan was to have industries collaborate with each other under government support through codes of competition. In order to prevent the big players from overshadowing the smaller businesses, there would be the following conditions. No blocking of admission to industrial association or groups, so the industrial group would remain representative of industry and to have a collective agreement of such codes. Also, these codes cannot create or encourage monopolies or oppression to smaller companies. Violation of these codes is deemed an unfair method of competition by the meaning of the Federal Trade Commissions Act. This includes things like false guarantees, endorsements, advertisements, prizes or gift offers, deceptive pricing, or misrepresentation of product. Furthermore, the president, as a condition of his approval of any such code, may impose conditions, including requirements for making reports and keeping accounts for the protection of consumers, competitors, employees, and others, and in also the furtherance of public interest. Finally, district courts were given jurisdiction over violations of fair competition and had to prevent such violations. When an approved code had been violated in an interstate or foreign transaction, it was treated as a misdemeanor and would be fined up to $500, and each day of violation was a separate offense. These are the parameters for establishing a code of fair competition. Section 7A grants certain benefits to employees, so let's go over it. Quote, every code of fair competition agreement and license approved, prescribed, or issued under this title shall contain the following conditions. Number 1. That employees shall have the right to organize and bargain collectively through representatives of their own choosing, and shall be free of the interference, restraint, or coercion of employers of labor or their agents in the designation of such representatives in self-organization or in other concerned activities for the purpose of collective bargaining or other mutual aid or protection. Number 2. That no employee and no one seeking employment shall be required as a condition of employment to join any company union or to refrain from joining, organizing, or assisting a labor organization of his own choosing. Number 3. That employers shall comply with maximum hours of labor, minimum rates of pay, and other conditions of employment, approved or prescribed by the President. Section 7B. These codes were to be established by mutual agreement, the standards as to the maximum hours of labor, minimum rates of pay, and such other conditions of employment as may be necessary in such trade or industry. So as we can see, Section 7 required codes to be collectively agreed upon by the representative group of an industry, and that these codes would have to settle hours of pay and minimum wage, as well as guaranteeing employees the ability and freedom to organize unions outside of the company's control or fear of retaliation. A pretty good deal. Over the next 2 years, the NRA would establish 557 basic codes and 208 supplementary codes that affected 22 million workers. The NRA was widely approved at its inception. However, sentiment soured as soon as it was seen as overbearing and bureaucratic. The codes were mostly written by larger companies and ignored at a convenience. In the end, it was seen as a failure to improve the economy. On the flip side, at least minimum wage was... Oh, hey, is that the Supreme Court? A case in 1935 would involve ALA Setcher Poultry Corporation for violating the, quote, Code of Fair Competition for the live poultry industry of the metropolitan area in and about the city of New York, end quote. The alleged violations were, quote, failure to observe in their place of business provisions fixing minimum wages and maximum hours for employees, permitting customers to select individual chickens from particular coops and half coops, sale of an unfit chicken, sales without compliance with municipal inspection regulations, and to slaughterers and dealers not licensed under such regulations, making false reports, and failure to make reports relating to the range of daily prices and volume of sales, end quote. The Poultry Corporation committed 18 violations of the Live Poultry Code, 2 of which violated minimum wage and maximum hours, and 1 count of conspiracy to commit these violations. The corporation said that the code was an unconstitutional delegation of legislative power, that this power was outside the authority of Congress, and it violated the Fifth Amendment. The government argued that hours and wages affect prices that could be part of interstate commerce, since slaughterhouse operators can pay less or reduce costs for lower prices, which increases demand for products. Also, the government argued that individual states do not enact laws for higher labor standards due to the belief that the commerce would move to states with lower standards and restrictions, thus requiring a federal law to be effective. The Circuit Court of Appeals sustained the conviction on the conspiracy count and 16 violations for the code, but reversed the conviction on the 2 counts which violated minimum wage and maximum hours, as they were deemed to be outside of congressional power of regulation. So again, minimum wage was ruled to be outside the government's ability. However, I do think it's important that we continue to finish this case. The other charges were appealed and eventually made their way to the Supreme Court. Chief Justice Hughes would write in the court opinion saying, interstate commerce ended once the poultry reached the defendant's slaughterhouse, since the following transactions were intrastate. The chickens were sold to retailers and butchers who then sold them to local customers. Therefore, the hours and wages had no relation to interstate commerce. The court reasoned that the government cannot influence these hours and wages because of the relation or indirect relation on prices, since this argument could then extend to, quote, the number of employees, rents, advertising, methods of doing business, etc., end quote. Meaning everything could then be classified under interstate commerce. Finally, the court said that it was not there to consider economic advantages of a centralized system, but to determine constitutionality, which the NIRA did not meet. Section 3 of the National Industrial Recovery Act was unconstitutional because it allowed the president to effectively write and approve the law himself. While some could say that the laws were to promote cooperation and not enforce it, these codes were not voluntary since the act said courts would rule on violations and punish offenders, thus intending to be law of the land. Essentially, Congress gave away its legislative powers, a constitutional violation already, over something it did not have jurisdiction over. Quote, the Congress is not permitted to abdicate or to transfer to others the essential legislative functions with which it is thus vested. And so, the court held the NIRA as unconstitutional due to not following the separation of powers, and reaffirming that minimum wage was outside federal oversight. It was a resounding 9-0 on May 27, 1935, with 2 weeks left in its 2-year scope. And hey, look at that, Louis Brandeis is finally being relevant to our story again. Not everything from the NIRA went out the window. Some parts were used in future acts. The National Labor Relations Act was signed on July 5, 1935. It prevented companies from penalizing workers for joining or organizing, allowing them for collective bargaining and collective action such as strikes, and preventing punishment or setting conditions to not join a union as a terms of employment. This is the thing that came from Section 7 of the NIRA. I guess it's time we should check on the state side again. A New York Act, Laws of 1933, Chapter 584, made it illegal for an employer to pay women at an oppressive or unreasonable wage defined as, quote, both less than the fair and reasonable value of the services rendered and less than sufficient to meet the minimum cost of living necessary for health, end quote. A fair wage was defined as, quote, fairly and reasonably commensurate with the value of the service or class of service rendered, end quote. If fair wages were not found, a commission would be appointed, and if they found women being paid unfair wages, a wage board would be appointed to recommend fair wage standards. A laundry owner, John Tipolato, was jailed by the commissioner for not abiding by the minimum wage set by this law. This was appealed in the New York Supreme Court, which struck down the law and upheld Atkins v. Children's Hospital, saying that the state does not have the power to interfere with contracts between employers and adult women workers in regard to the amount of the wages paid. The New York Court of Appeals interpreted fair wage to not only mean fair and reasonable service, but also the minimum cost of living for health, and decided that it was unconstitutional. Associate Justice Butler would follow up on the Supreme Court opinion upholding the Atkins precedent 5-4. Another swing and a miss. Quote, the decision in Atkins v. Children's Hospital, Supra, and the reasoning upon which it rests clearly show that the state is without power by any form of legislation to prohibit, change, or nullify contracts between employers and adult women workers as to the amount of wages to be paid. The dominant issue in that case was whether Congress had power to establish minimum wages for adult women workers in the District of Columbia. The opinion directly answers in the negative. The ruling that defects in the prescribed standard stamped the act of Congress as arbitrary and invalid as an additional ground of subordinate consequence. End quote. To kind of get an idea of the court at this time, the Supreme Court had the Three Musketeers, who were the progressive side of the court, consisting of Justice Brandeis, Stone, and Cardozo. On the other side, the majority of the court was held by the conservative members called the Four Horsemen: Justice Butler, McReynolds, Sutherland, and Van Devanter. Chief Justice Hughes and Roberts were the swing votes, but were also split, with Hughes tending to be more progressive and Roberts tending to be more conservative. It certainly feels like we were walking in circles at this point. The Supreme Court would rule time and time again that neither the federal or state government had the ability to enforce minimum wage. But there was one state that somehow kept going: Washington. As I said before, it was the only state to keep enforcing its law through legal means in 1931, and its turn in the Supreme Court would come in 1937. Elsie Parrish, a chambermaid for the Cascadian Hotel in Wenatchee, Washington, sued the West Coast Hotel Company for the difference of what she was paid and the minimum wage set by the Industrial Welfare Committee and the Supervisor of Women in Industry, which was $14.50 per week for 48 hours of work. The trial court ruled in favor of the hotel, using Adkins as precedent. The Washington Supreme Court was appealed to and ruled in favor of Parrish. It would then get appealed to the Supreme Court. Justice Hughes and the Three Musketeers believed that the constitutional question of Adkins v. Children's Hospital should be re-examined. Like before, they reiterated their stance that liberty could not be taken away without due process. However, they also said restricting contracts between employers and employees have long been established in the name of public interest, such as Holden v. Hardy, Knoxville Iron Company v. Harbison, and Bunting v. Oregon, to name a few. These cases were cited as examples of the state ensuring, quote, suitable protection of health and safety, and that peace and good order may be promoted through regulations designed to ensure wholesome conditions of work and freedom from oppression, end quote. Furthermore, Mueller v. Oregon emphasized the physical difference between men and women and the need to protect women to benefit of all society. Quote, though limitations upon personal and contractual rights may be removed by legislation, there is that in her disposition and habits of life which will operate against a full assertion of these rights. She will still be where some legislation to protect her seems necessary to secure a real equality of right, end quote. Women were, quote, properly placed in a class by herself, and legislation designed for her protection may be sustained even when, like legislation, is not necessary for men and could not be sustained, end quote. Hughes said that the 14th Amendment is not supposed to enforce some form of equality upon all, and so different legislation for different classes may be appropriate. Hughes also quoted Chief Justice Taft, who had stated that hours which had been upheld before is the same as wage, with no distinction. Taft said in his dissenting opinion in Adkins, quote, in absolute freedom of contract, the one term is as important as the other, for both enter equally into consideration given and received. A restriction as to the one is not greater in essence than the other, and is of the same kind. One is the multiplier, and the other is the multiplicative. Hughes wrote that the public interest in the health of women from employers, and that they are as a class of receiving the least pay and low bargaining power, and so were victims to most likely accept those types of conditions. He would reiterate that the soundness of policy is not tied to constitutionality. Quote, even if the wisdom of the policy be regarded as debatable and its effects uncertain, still the legislature is entitled to its judgment, end quote. He would also say that this is a matter of public interest, since the taxpayer, which ultimately will be the ones to pay, if not the businesses. Quote, the exploitation of a class of workers who are in an unequal position with respect to bargaining power and are thus relatively defenseless against a denial of a living wage, is not only detrimental to their health and well-being, but casts a direct burden for their support upon the community. What these workers lose in wages, the taxpayers are called upon to pay. The bare cost of living must be met. End quote. And also, quote, the community is not bound to provide what is in effect a subsidy for unconscionable employers. End quote. Hughes also recognized and supported legislation for different classes with the following. Quote, the legislature is free to recognize degrees of harm, and it may confine its restrictions to those classes of cases where the need is deemed to be clearest. If the law presumably hits the evil where it is most felt, it is not to be overthrown because there are other instances to which it may have been applied. End quote. And that, quote, there is no doctrinaire requirement that the legislation should be couched in all-embracing terms. End quote. On the other side of the aisle, Justice Sutherland would write the opinion of the Four Horsemen. He said that the other cases cited by Hughes were irrelevant as shown in Atkins, and were used in other cases as precedent of its irrelevance. He and other conservative justices said that the Constitution does not change with economic times, only by the will of the people and their sovereign capacity through the government to amend the Constitution. The Supreme Court can only interpret. It does not have the power to amend through interpretation. He emphasized the separation of powers to leave legislative duties to Congress, and that Atkins was identical to the current case. He said Atkins had pointed out the difference between labor hours and wages, which was shown in Bunting v. Oregon. Hughes said that minimum wage is not a matter of public interest. Quote, it is simply and exclusively a law fixing wages for adult women who are legally as capable of contracting for themselves as men, and cannot be sustained unless upon principles apart from those involved in cases already decided by the court. He stressed that payment is based upon agreement, not necessity or lifestyle of another party, and that this law fails to account for the ability of the employers to pay it. He said that the equal ability to form contracts of men and women are the same, since it does not depend upon sex. Therefore, restricting only women's ability to pay is arbitrary. The court was still the same as it was in Moorhead v. New York. But in a surprising turn of events, Roberts would side with the more left-leaning justices, voting 5-4, overruling Atkins. During all of this, there was a court-packing threat from Roosevelt called the Judicial Procedures Reform Bill of 1937. This would allow the president to appoint new justices for every justice over 70 years old, up to a maximum of 6. Some believe that this threat is what caused the Supreme Court to concede on the president's agenda in order to preserve the size of the court. Maybe. However, according to Marianne McKenna's book, Franklin Roosevelt and the Great Constitutional War, the Court-Packing Crisis of 1937, another story is presented. Chief Justice Hughes and Justice Roberts maintained that they had a 4-4 affirmation of Washington's law on December 19, 1936, before the court-packing announcement happened, which was on February 5, 1937. Hughes said he was waiting for a decisive 5-4 vote with the return of Harlan Fiske Stone from his illness, which he did on February 1, 1937. On March 9th, Roosevelt would do his 9th fireside speech to the general public, which he would talk about his court-packing bill. 20 days later, on March 29th, the Supreme Court opinion would be published. Now, Justice Roberts destroyed most of his manuscripts before leaving office and said that the president's actions had no influence on his decision. Perhaps. While a 4-4 affirmation would have upheld the law like it did in Steadily v. O'Hara, it would have not set national precedent like Atkins did. Regardless of which story is believed, thanks to the 5-4 majority, Atkins would be overruled. Later, one of the conservative judges, Van Devanter, retired in 1937 after Supreme Court justice pensions were restored to their full amount. The pensions were halved as a part of an earlier policy of the New Deal to save money. Coupled with Roberts' changing opinion, the court packing lost any real momentum. Roosevelt's proposal was seen as undemocratic to the public and an overreach to the Supreme Court, so it likely would have never been voted on. Roosevelt eventually did pack the courts in a way by naming the next 8 Supreme Court judges. Not all of them served at the same time, though. However, we do see some familiar faces. Felix Frankfurter was appointed in 1939, replacing Cardozo. Looks like he finally caught up to Brandeis again. This really isn't the end of the story, though. Adkins is no longer an obstacle, but that did not mean minimum wage suddenly existed. Legislation would need to be drafted and signed. Thanks to Jonathan Grossman of the Department of Labor, his article, Fair Labor Standards Act of 1938, Maximum Struggle for a Minimum Wage, can really just show how the final end of this story goes. During the NIRA case, Secretary Perkins worked on 2 bills that the Supreme Court would allow, since many of Roosevelt's actions were seen as unconstitutional. She said, quote, "I have something up my sleeve. I've got 2 bills locked in the lower left-hand drawer of my desk against an emergency." Roosevelt laughed and said, "There's New England caution for you. You're pretty unconstitutional, aren't you?" The first of these 2 bills was called the Public Contracts Act of 1936, which set an 8-hour day and a 40-hour week for government contractors, and that they must be over 16 years if they were boys or 18 years if they were girls, and had to pay a, quote, prevailing minimum wage, end quote, set by the Secretary of Labor. It passed. After the switch in the court by Roberts, Roosevelt asked Perkins, "What happened to that nice unconstitutional bill you tucked away?" Secretary Perkins sent her draft bill to Thomas Corrigan and Benjamin Cohen, 2 of Roosevelt's brain trusts, to prevent any objections from the Supreme Court. These 2 would work with Senator Hugo Black to build the political will behind it. Previously, Senator Hugo Black had drafted a minimum wage and 30-hour work week in 1932. Obviously, this did not come to pass. With the Brain Trust, he sponsored a new bill, and it became known as the Black-Connery Bill, proposing a 40-cent an hour minimum wage and 40-hour maximum work week, as well as a minimum working age of 16 years old. It would pass in the Senate, but it would be tied up in the House Rules Committee, which did not allow it to come to a vote in the House of Representatives. Roosevelt would eventually call for a special session of Congress to put this to a vote, and Representative Mary Norton would gather 218 signatures to put the bill to a vote. However, this vote would end in a 218 to 198, which sent the bill back to the Labor Committee. This would fail in the House of Representatives without further action. During this time, actually, Hugo Black would also become the first to replace the retired conservative Associate Justice Willis Van Devanter after the West Coast Hotel Company v. Parrish case. Roosevelt would try again by telling Perkins, quote, "Can't it be boiled down to 2 pages, end quote. The long length of the bill was done with the Supreme Court's previous objections in mind, but with West Coast v. Parrish giving a green light to this type of legislation, perhaps Roosevelt was a bit more comfortable with a shorter bill, especially since its complexity was called for a reason for its failure. Now, laws in layman terms are difficult to enforce. However, the bill was ultimately reduced from 40 pages to 10 pages. And after a great deal of politics and 72 amendments, this bill would eventually become known as the Fair Labor Standards Act of 1938. It passed in the House in a 291 to 98 vote, and in the Senate without a record of the votes. It was signed by Roosevelt on June 25, 1938, effective on October 24th. It would set 25 cents an hour for interstate commerce, 30 cents for the next 6 years, and 40 cents an hour after the 7th year. It would also state that if there were higher minimum wage laws in the states or other federal laws, those would take precedent. As a side note, it gave 1.5 times overtime pay for 40-hour days and prohibited child labor. I know, interstate commerce feels a bit vague, and you might be still wondering about intrastate commerce and possibly your own job. There's still plenty of things that happened from then to now to make the law we know today, but all of this is another story for another time. We finally learned how we got, lost, and got again minimum wage. It was all through decades of politics, court cases, and people fighting for their rights, which all led up to this moment. It's been exhausting. I appreciate you all, and thank you for listening.